Please. Entire discussion of majority was in federal structure in a state center context. The significance of
One second. Supplementary.
Yes,
Today.
Everyone. Yes, please. And
Para 2. The significance of Delhi as a capital and its control by the state government is recognized. Lord, it should be central government. Lord, that's a typo. Para 2, page Para 2, Manoj, there is a typo. Manoj. Significance of Delhi as a capital and its control by the state government. It should be central government. Your Lordship would find that in the context subsequently, is recognized both prior to the constitution and after the constitution. But prior to, I have read, Manoj, that the center must keep its control over the capital. Article 239AA is also so structured that while providing for a democratic government in the NCT of Delhi, the major control of the major stakeholder, that is the government of the entire nation, is retained over the capital of the country. The entire issue deserves to be viewed keeping this backdrop in mind. The entire discussion of the majority judgment on federalism, etc., misses this viewpoint, vital point, in the entire discussion on federalism.
Just do this as we go along. Tell your junior, the nodal counsel, Padmesh, who's been looking after this, to make whatever corrections, like state, center, or as you go along, you can do it on your laptop and mail it to the court master. So he'll immediately mail out
simultaneously. But subsequent para makes it clear that
he'll be able to do it right here, because as you are correcting as you go along, he can correct it.
We shall do that. I am obliged. Under the title Federalism, Collaborative Federalism, Pragmatic Federalism, and Concept of Federalism and Balance are devoted to issues which can apply only to states. The concurring view, my Lord, the Chief Justice, however, recognizes this concept in the judgment so and so. I'll read para 360. While bearing these fundamental constitutional principles of a democracy in mind, a balance has to be struck with the second of the above elements, which recognizes the special status of the NCT. The NCT represents the aspirations of the residents of its territory, but it embodies in its character as a capital city the political symbolism underlying national governance. The circumstances pertaining to the governance of NCT may have a direct and immediate impact upon the collective welfare of the nation. This is the rationale for the exclusion of the subject of public order, police and land from legislative power and necessarily from the executive power of the NCT. These considerations would necessarily require a careful balance between the two principles. Of the two principles must be given adequate weight, producing a result which promotes the basic constitutional value of participatory democracy, while at the same time preserving fundamental concerns in the secure governance of the nation. Then, my lords, were in page 389. Undoubtedly, the governance of NCT involves national imperatives. They must also weigh in the balance. The proviso to clause 4 of Article 239AA is constitutional indicator of the national concern which were borne in mind when the constituent power was exercised, established the NCT as a political arm of the governance by a special constitutional provision. Those national imperatives have led to the carving out of areas of police, public order and land from the sphere of legislative authority of the Legislative Assembly and their entrustment to the Parliament. But insofar as my lords have said somewhere else, it's not coming here. Again, it is the sense of national imperative which led to the constituent power being so modulated in relation to the NCT as to allow parliamentary legislative authority over all entries in the state list in addition to the concurrent list. Parliament does not exercise legislative authority in relation to the state list entries as regards the states in India unless a matter falls within the ambit of Article 252 or 253. Parliamentary legislative control over union territories has been broadened precisely as a manifestation of national imperatives or concerns. The executive power of the Council of Ministers being coextensive with the legislative power, this aspect has to be borne in mind. The true challenge is to maintain that delicate balance in a federating union such as ours, which ensures that national concerns are preserved in the interest of unity and integrity of the nation, while at the same time, local aspirations exercised through the democratic functioning of the elected government find expression in our politics. Then, my lords, the Chief Justice was pleased to observe in 390, the constitutional principle which emerges is that while Delhi presents a special case, quite unlike other union territories, the constitutional provisions governing it are an amalgam between national concerns reflected in control by the union and representative democracy expressed through the mandate of a council of ministers which owe collective responsibility to a directly elected legislature. There is no gainsaying the fact that the control by the union is also control of the president acting on the aid and advice of the Union Council of Ministers, which in turn owes collective responsibility to the parliament. Constitutional statesmanship between the two levels of governance, the center and the union territory, ought to ensure that practical issues are resolved with a sense of political maturity and administrative experience. This court has to step in only because skirmishes between the two have raised constitutional issues of proper distribution of executive control over national capital territory. In this context, what I said, from 92 till date, with a level of political maturity, though there were different political regimes in center and state, everything worked smooth. Then, my lords were pleased to say at 471, the exercise of the constituent power to introduce Article 239AA was cognizant of the necessity to protect national interest inherent in the governance of a national capital. A sense of permanence and stability was sought to be attributed to the arrangements made for governing Delhi by bringing in a constitutional amendment, both in terms of the reach of the legislative power as well as in relation to the exercise of executive power. The special constitutional arrangements for Delhi recognizes that the governance of Delhi implicates a sense of national interest. When matters of national interest arise, they would predicate a predominant role of institutions of national governance. Then, my Lord Justice Bhushan is pleased to devote one para. The word capital is derived from Latin word caput, meaning head, and denotes a certain primacy status associated with the very idea of a capital. Delhi is the national capital of the country. For the purposes of this case, it is not necessary to notice early history of Delhi. During the British period, your lordships can skip the history your lordships have seen. Now I am coming directly how I respectfully assist your lordships, regulated by the Constitution, and separate and specific powers, duties, responsibilities, and provisions are made. Part 5 entirely devoted to the Union. Part 6 entirely devoted to states, and Part 8 entirely devoted to union territories, which was introduced by 7th Amendment. The Part 8 was introduced by 7th Amendment. The above are the units of governance contemplated under the Constitution, all of which consist of elected representatives and have been given the legislative and corresponding executive powers depending upon the nature of the union. The union which is contemplated constitutionally and is contained in Part 5 of the Constitution represents the collective will of the entire nation, and therefore they have legislative and corresponding powers over both List 1 and List 3, subject to Article 245. The state which are contemplated constitutionally and is contained under Part 6 of the Constitution reflects the democratic will of only one state, and therefore only those subjects are conferred upon it which concerns the residents of a state. The union territory which is contemplated constitutionally and is contained in Part 8 of the Constitution merely represents an extension of the union, and therefore there is no concept of federalism between the union and its extended area. the union territories are retained under the control of the union because of different strategic significance of each union territory, be it defense or such other significance. Delhi has the distinct significance of being the capital. The union territory, apart from being an extension of the union, is a reflection of will of people residing in the union territory, and therefore its constitutional status is less than that of the state and more than that of the municipalities and panchayats. Because they are also units of governance under the constitution now, after part 9 and 9E. The constitution has therefore given a sui generis position to Delhi, being the capital of such a big nation, and has very consciously restricted its powers only to those entries in list 2, which can be applicable to a union territory. There is one only place in the entire constitution where the supremacy of parliament is constitutionally recognized by conferring jurisdiction even on list 2 subjects, and that is when union territories are concerned.
There's some problem with this sentence. Perhaps you'll have to recast this.
Last portion.
There is only place in the entire constitution.
There is only place in the entire constitution where the supremacy of parliament is constitutionally recognized. We will rephrase it. What I am intending to submit is that normally parliament's power is list 1 and list 3.
Here it's list 1, 2, and 3 over UTs.
Yes. Yeah.
That's what you're saying.
That's what I am saying. That is the only place in case of union territory that supremacy is given even in 2. Otherwise, no other unit of governance has this provision. Having given
But
clear.
Mr. Mehta, it may be difficult to accept your submission that, look, federalism as a concept applies only where the union and the states. You know, there may be also a sense of hybrid federalism where, where even as between the union territory of Delhi and the state and the center, some elements of the federal structure also apply there. May not be to the same extent as in relation to a full-fledged state. But in carving out a constitutional amendment for the union territory of Delhi, that was also in reflection of a certain degree of federal aspiration. So you're right. I mean, it's obviously not a state. So, you know, it doesn't have all the trappings of a state, but it has some trappings of a state. So as to implicate federal concepts, even in the relationship between the center and the union territory.
May I rephrase my submission? Lord, the principle of federalism will not be completely ousted in the relationship between the union and the union territory. But the principles which govern the relationship between union and the state, that would not be the federalism. It would be, my lord, as your lordships have rightly suggested, a kind of a hybrid federalism with supremacy to the center and, my lord, federal structure, constitutional earmarks under Article 239.
Why do you postulate federalism? I mean, as an abstract constitutional theory, federalism implies when you don't have a unitary form of government. That is, you have a demarcated polity where governance is distributed both in legislative and executive terms at different levels, between the center, between the states, between units within a state also. So that these characteristics of federalism are prevalent even in relation to union territory. In fact, I would think that even, say, the panchayats, the municipal corporations, which now come in by virtue of a constitutional amendment, they are reflective of the need for local governance. You see,
decentralization of power.
Decentralization of power.
Look, I'm not pitching my case. I make it very clear that there is complete absence of principle of federalism between union and union territory. But I'm saying the way majority considers that it is akin to the federalism between full-fledged states and union may not be a correct view.
All right.
In union territory, it would be a hybrid kind of a federalism where decentralization of power, there is no, what are the fundamentals of federalism? The federal unit is not dependent upon the federating unit, namely the state, etc., is not dependent upon its source of power to the union. Constitution is the source of power. So federalism would apply. But the nature of federalism, the threshold, etc., would be different than that of a state. That's, I'm not pitching it to an unrealistically high level.
Yes.
So you're willing to state that the boundaries will be hemmed in, but there will be boundaries where the center will keep its hands off.
Look, I would not put it, yes, I bow down to what has fallen from your right. But in case of union territories having legislature, there would be a federalism. Look, there are union territories, no legislature. We directly control. There is no elected government. So there is no question of there being any federalism. But in two, Puducherry and Delhi, there is a legislative assembly. The concept of federalism, as my Lord, the Chief Justice of India rightly says, would apply. But the threshold, as your Lord Ladyship rightly puts it, boundaries would differ. It would not be all-encompassing federalism. In any case, my Lord, India is otherwise also never a complete federal or complete unitary. It's quasi-federal, quasi-unitary. Some provisions are complete unitary, some provisions are completely federal in nature, my Lord. So we have chosen that model.
Yes. So let's go ahead.
My Lord, your Lordships have referred to it, my Lord the Chief Justice, as centralizing trade. So that I made myself clear. I'm not putting it.
All right.
Let's
see para 10 onwards.
10. Having given clear-cut demarcation among the units of governance within the country and keeping in mind an undisputed position that Delhi is the union territory. Lord NDMC 9-judge judgment and your Lordship's Constitution bench judgment. That it is union territory.
Yes.
Different from the union and the state, it is required to be pointed out that the provisions of services, this is very, very crucial. This is the heart of the matter. It is required to be pointed out that the provisions of services are made in chapter 14 of the Constitution having the title Services under the Union and the States. It does not categorically mention union territories. There is a deliberate silence, which will become clear further, that it's not just a coincidence that it is not included. There is a conscious omission. The Constitution, which is fully aware of three units of governance, that is union, the state and the union territory, categorically excludes the union territory from the said chapter under the heading services under the union and the states. In other words, there are only two categories of services contemplated under union services or posts in connection with affairs of the union. In connection with the affairs of the union is the phrase I have borrowed from Article 309 itself. And two, state services or posts in connection with affairs of any state. There is no contemplation of any separate and independent services for union territories, since any union territory, whether with or without legislature, is constitutionally an extension of the union, and not only statutes but the Constitution recognizes the above position as stated above. All India services officers selected by UPSC or a board controlled by the central government are deployed in connection with the affairs of the union territory, since such affairs are necessarily in connections with the affairs of the union. The inevitable conclusion in chapter 14 under the heading services under the union and the state is that it does not apply to union territory, which becomes clear from Article 308 contained in Part 14 itself. Not the first article, and this is again not clinching in my respectful submission. At this juncture, it is relevant to note, and you may not note this, this is very, very, very relevant. At this juncture, it is relevant to note that Article 308 of the Constitution was in existence even prior to the insertion of the concept of union territory, which came to be amended by 7th Amendment. Union territory came in 7th Amendment, but 308 was there, by which the concept of union territory is also introduced in Part 8 of the Constitution, and the concept of an administrator to administer the affairs of union territory was also introduced by very same amendment under Article 239. Though Article 308 came to be amended simultaneously with introduction of union territory, and the contemplation of an administrator to administer the same, the Parliament did not incorporate union territory within the meaning of the expression state. Lord, this is the amended provision. Lord, kindly see the title, part 14, Services under the Union and the State, Chapter 1, Services, Interpretation. In this part, unless the context otherwise requires, the expression state does not include state of Jammu and Kashmir. This is the only amendment, my Lord. Simultaneously, this is a part of 7th Amendment. The Parliament could have said state would include union territories because elsewhere in other provisions, Parliament has said in the 7th Amendment itself that the word state here would include union territory. Parliament doesn't say, my Lord, in the chapter of service. And please bear one factor in mind. Lord, thereafter it comes, Lord. Kindly see, my Lord, what was the earlier provision which was amended. My Lord, there is an asterisk here. An asterisk, my Lord, is also quoted. It's not my paraphrasing. Substituted by the Constitution 7th Amendment Act, Section 29 and Schedule 4. Earlier, my Lord, it was means a state specified in Part A or Part B of the first schedule. So earlier, prior to the 7th Amendment, the position was in this part, unless the context otherwise requires, the expression state means Part A and Part B states. Delhi was not a Part A or Part B states. I'll come to that later on, my Lord. That is one more clinching indication. Then, my Lord, 309. Recruitment and conditions of service of persons serving the union or the state. Provided that subject to the provisions of this Constitution, acts of the appropriate legislature may regulate the recruitment and conditions of service of persons appointed to public services and posts. Please note, my Lord, in connection with affairs of the union or any state. Those who are working with GNCP Delhi are working for the affairs of the union. Because for this chapter, there is no union territory. Provided that it shall be competent for the President or such person as he may direct in case of services and posts in connection with the affairs of the union and for the governor of a state. So two things here. Or such person as he may direct in case of services and posts in connection with affairs of the state to make rules regulating the recruitment and conditions of service of the persons appointed to such services and posts until provision, etc. There are two things. By this very amendment, there is an asterisk. The word governor came to be introduced. That is 7th Amendment. 7th Amendment also stipulates administrator for union territory. It does not say governor or administrator. Yes. Second, there is second asterisk. Earlier, prior to 7th Amendment, it used to say Raj Pramukh. Now, Raj Pramukh in 7th Amendment is substituted or amended with the word governor. Kindly bear these two facts in mind. Administrator who comes by this very amendment is not included, and Raj Pramukh becomes governor. There is a significance. Para 15. Firstly, not only the recruitment with respect to the person serving in connection with the affairs of the union is exclusively left to the Parliament under entry 7 list 1, but their conditions of service is also left to the. There is an occupied field. Those who are serving in the affairs of the union are appointed by the law made under entry 7 list 1. Now, but it cannot be disputed that the term condition of service includes within it posting, transfer, promotion, departmental action, etc. Secondly, there is one unimpeachable indication that the term union territory is kept outside the purview of 309. It is important to note that Article 309 confers the power to legislate an appropriate law and or make rules governing condition of service of persons appointed for the public services and posts in connection with affairs of the union or any state. This makes it clear that entry 41 list 2 can never be made available to union territory as persons appointed in connection with affairs of the union territory are necessarily appointed in connection with the affairs of the union, and the field is occupied by either legislative enactment or well, it should be or stroke and, I'll change, and rules made thereunder, namely under entry 70 list 1, which reads as under, well, the entry under which present regime functions for UT, Union Public Service Commissions, All India Services, and Union Public Service Commission. But all India services, I'll be able to show that not from the statutory regime. It is submitted that at this juncture, and elaborated later that there are 3 tiers of services in NCT of Delhi occupied by public servants appointed in connection with the affairs of the union. All India service officers who are governed by All India Services Act 1951, which is undisputably made in exercise of powers under entry 70 list 1. Then DENIC's employees who are appointed and who are governed by DENIC rules, which are made by the President of India in exercise of rule-making power conferred under proviso to Article 309 of the Constitution. And C, subordinate public servants appointed under DAS rules 2022, which rules are also made in exercise of powers under the proviso to Article 309 of the Constitution, clearly indicating that they are working in the affairs of the union. Since the field is already occupied by the legislation made under Article 70 list 1 and rules framed under the proviso to Article 309 of the Constitution, and the chapter of services does not contemplate separate services for covering union territories, the question of examining as to whether entry 41 list 2 would apply to union territory of Delhi or not may not be necessary unless it is established that Delhi is a state. Delhi is undisputably not a state. But A, NDMC, B is relevant. Constitution's 7th Amendment Act, which introduced the concept of union territory, made a very significant amendment in the proviso. Hierarchy of units of governance in India existing at the time of 7th Amendment needs to be understood. There were 4 categories of states, namely Part A, B, C, and D, which were having governors for Part A states, Raj Pramukh for Part B states, and chief commissioners for Part C and D states. When 7th Amendment came, there cannot be and there is no dispute that Delhi was a Part C state having a chief commissioner, which became administratable now after 7th Amendment and the union territory. Now kindly see the proviso to Article 309. Instead of Raj Pramukh, that is Part B state goes, the constitutional amendment says governor, meaning thereby it applies only to Part A states, which are all full-fledged states. The word administrator is conspicuously absent, which was applicable to Part C and D states. They become union territories or some of them merged with other states. The Parliament, while amending the Constitution by 7th Constitutional Amendment, not only not include union territory while defining the expression state under Article 308 of the Constitution and not include administrator in the proviso to 309, but even omitted the reference to Raj Pramukh in proviso to Article 309 and thereby excluded even Part B states from the purview of Part 14, that is services. This inevitably reflects that Parliament very consciously omitted any separate service for union territory from Part 14, it should be 4 Part 14, under the heading of services under the union and the states, but even Part B states under the Raj Pramukhs were also kept out of Part 14. So only Part 1, Part A states, having governors even before that, big full-fledged states. Now, A and B were merged they became full-fledged states after the seventh amendment. So that goes. But another indication. Chapter 2 contained in part 14 relating to services provides for Public Service Commission, which reads as under 315. But same chapter, services, which reads as under. Subject to the provisions of this article, there shall be a Public Service Commission for the Union and a Public Service Commission for each state. Your Lordships can skip, come to sub-article 4. The Public Service Commission for the Union, if requested so to do by the governor of a state, may with the approval of President agree to serve all or any of the needs of that state. The state can say that UPSC will select, I don't want to have my own service commission. Small states do it for financial reasons, etc. That we don't want to incur infrastructure expenses, etc. Let UPSC decide our role. But kindly see the asterisk, the words or Raj Pramukh omitted by the 7th constitutional amendment. Administrator is not added. Though same amendment introduced the concept of union territory and administrator for it.
Though interestingly, the J&K Reorganization Act incorporates a public service commission for the UTs of Jammu and Kashmir.
I will immediately answer that. Lord. I was to come to it later, but since that has occurred to my Lord, the Chief Justice of India, your Lordship, kindly take the Constitution. There is a clear-cut answer. There is a clear-cut answer. Kindly take Article 239AA. Your Lordship said note 3.
239AA3.
AA sub-article 3. Subject to the provisions of this Constitution, the Legislative Assembly shall have power to make laws for the whole or any part of National Capital Territory with respect to any of the matters enumerated in the state list or in the concurrent list, insofar as any such matter is applicable to Union territories. Now, for the testing the argument, accept my submission hypothetically that services are not. Services fall within this exception of insofar as, and specific exclusions. Kindly see B. Nothing in subclause A shall derogate from the powers of Parliament under this Constitution to make laws with respect to any matter for a union territory or any part thereof. So B says that Parliament can, by making law, give powers even to excluded categories to the union territory. I hope, Lord, I am clear. A restricts the power of union territory. 1, specific exclusions, 3 in number, and 2nd, implied exclusion if it falls within insofar as such matter is applicable. But Parliament can say that no, we may even give police power to one union territory. That is B. I'll again read. Nothing in subclause A shall derogate.
239A is only applicable to Delhi.
Delhi, not
Delhi only.
Kashmir.
It have to be.
I'm saying that. I'm saying something else. Nothing in, tomorrow, kindly see,
What 239, this clause 3B says is that in relation to Delhi also, Parliament can legislate even on the state list.
Exactly, I'm saying, that's what precisely I'm saying. Parliament can say that for NCT of Delhi, there would be a separate state public service commission, or there would be, even police will be under the Delhi administration.
So according to you, the Parliament, while enacting the
State Reorganization Act is a parliamentary law.
they can always delegate, they can constitute an institution such as a public service.
Yes. That is number 1. Number 2, kindly see, my lord, Article 4.
It's the union which constituted.
Which constituted earlier, kindly see, Jammu and Kashmir again is a sui generis, example. There was a state public service commission for good reasons, which are not relevant here, they were bifurcated into two union territories. So the parliament wanted continuance of the Public Service Commission, but leaving it at that. Parliament can and parliament did by law said that there are no restrictions. You have your own Public Service Commission. That can be done to even Union Territory of Lakshadweep. Parliament can say that you have your own Lakshadweep police service, or your land issue is also given to
Right, but if Parliament is constituting a public service commission for a union territory, which is a power which Parliament exercises under which entry?
Article 4. Article 4. Article 4, not sub-article 4. Article 4. Kindly see them. Article 4. First, kindly see 3.
Oh, the question is
Formation of
that the constitution of the Service Commission in the state of Jammu and Kashmir, if it is in exercise of the parliamentary power, or did the state legislative assembly has exercised that?
parliamentary power. It is
How is that, if that is the case, then how is that relatable to Article 4? Not relatable to.
First, kindly see 3.
Yeah.
It is parliament made state reorganization. First of all, it's not after UT of JLK, there is no legislative assembly as of now. So the question of assembly making would not arise. Parliament may by law form a new state by separation of territory from any state, or by uniting two or more states or part of states, or by uniting any territory to a part of any state. Increase the area of any state, diminish the area of any state, alter the boundaries of any state, alter the name of any state, provided that no bill for the purpose shall be introduced in either House of Parliament, except on the recommendation of the President, and unless where the proposal contained in the bill affects the area, boundaries, or name of any of the states, the bill has been referred by the President to the legislature of that state for expressing its
But I tell you the problem with this submission. Parliament under entry 70 of list 1 can legislate to constitute a union public service commission. So under entry 70 of list 1, they cannot constitute a public service commission for a union territory. Entry 41 of list 2, according to you, refers to a state public service commission. That will not apply to a union territory.
which
That means
unless
that
Parliament
means-
views.
No. Therefore, even Parliament cannot legislate under entry 40 of list 2 to constitute a union territory public service commission. So there is neither a power in Parliament to do that under entry
I'll
70,
answer this in
nor is
detail.
there a power under entry 40 by virtue of your argument which takes away that power, because that is not a power which is relatable. It doesn't apply to a union territory.
Would your lordships again see para 4, Article 4? And taking their argument at its
But it's
best.
still an answer to it.
No, I'll
Which is,
not say that.
no, I'll tell you, there's only one way to answer it, and which is to say that though Parliament does not have an express power either under entry 70 or entry 41 of list, entry 70 of L1 or entry 70 of list 2, Parliament will rely upon, the ragbag, as Justice Venkat Chilaya called it, under entry 97. That's the only way to
There are two answers.
break the conundrum.
There are
Parliament
two
can
answers.
rely upon anything which is not specifically conferred is vested in Parliament.
There are two answers. Kindly read along with me once again Article 4. Any law referred to in Article 2 or 3 shall contain such provisions for the amendment of the first schedule and the fourth schedule as may be necessary to give effect to the provisions of the law, and may also contain any such supplemental, incidental, and consequential provisions, including provisions as to representation in Parliament and in legislature of or legislatures of the state or states affected. No such law, this is Reorganization Act, shall be deemed to be an amendment of this constitution for the purpose of Article 368.
That
So
will
maybe
not help
Parliament
you.
amended the constitution.
That will not help you, Mrs. Surya. A first schedule only deals with the territories of the states. What is the territory? Territorial extent.
No, and-
Fourth schedule deals with the council of states.
Leave the territory.
So when
Can
it
you read
gives you
further?
supplementary powers, that's in relation to the first schedule and the fourth schedule. That will not, possibly the only way to save this is to say entry 97.
Lord, kindly see that. And there is another answer as
The
well.
only way we can say it. Entry 97.
Mr. Mehta,
Yes.
see what is pointed out to you. Union powers are under entry 7. Constitution bench judgment also, correct? Union territory is not, it is not a state. So entry 41 may not be applicable so far the union territory is concerned. But the question which is posed is under which provision of law with respect to the union territory, correct? The Union Public Service Commission shall be applicable.
State
Look,
public
would your
service.
lordship-
State public service.
State public.
State. Lord, would your lordships come to Article 246?
Because earlier you said that NT 41 shall not be applicable at all because it is not a state. Because it is under Article 239 AA, it is a special power, hybrid power which is given, which is not equivalent to state at all. Therefore, to apply NT 41, correct, will be erroneous.
My lords.
Then under which provision, correct, it will be applicable. That is what you have said Article 302, 3 services, A, B, C, correct, different, all these things that we have
I'm on
noted.
Jammu Kashmir, my lord. I will kindly see Article 246.
And you get the that act, Jammu and Kashmir Act also.
I'll just.
So that you can have some idea
I'll
before making any submission on that. Under which provision, under which powers
I'll-
that law is
Lord,
enacted.
I'll definitely, my lord, apply myself to that and my lord respond.
Because you will immediately get in exercise the powers under so and so, or in exercise the powers. Immediately you can get from that act.
I'll just not get it, my lord, but would your lordship, I'll come to it, my lord, a little later, my lord. I'll apply myself. But please see 246.
That it's covered by 246(4), that Parliament can legislate on any matter on respect of a territory which is not in a state.
And even enumerated in the state list. Kindly see, my lord, Parliament has power to make laws with respect to any matter for any part of the territory of India, not included in a state, notwithstanding that such matter is a matter enumerated in the state list.
So it is Parliament's legislative powers with respect to union territories.
Yes. So Parliament can exercise the powers under entry 41 list 2 for this territory because when the reorganization
No,
act,
that will not help you again, because look at the last part of this 240. Notwithstanding that such matter is a matter enumerated in the state list. So even if a matter is in the state list, Parliament can still exercise power on that area for a union territory.
that's what I'm
This is
saying.
not even in the state list according to you.
No, 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 no. No, no, no.
And also the fact that 246 falls under chapter 1 of part 11, which is relationship with
Kindly see, my lord, kindly read it again. Kindly, my lord, read it again.
Mr. Mehta, the answer possibly to my question is that this will only be relatable to entry 97 of list 1. Any matter not enumerated in any other list.
any other matter.
That is, my lord, that can be the answer, my lord. But, my lord, again, my lord,
If you have got,
I'll respond.
if you have
Just
got any
reflect on
answer,
it.
subsequently you can
Reflect on it.
clarify and reflect.
My lord, but one.
All right, let's go to
one
para 25.
My lord, even if, my lord, even if my learned friend is right, that would mean that provision in the Jammu Kashmir Reorganization Act may be bad in law. That would not mean that the Delhi would have the legislative power to have.
That you have so said in the earlier, that they have to show under which provision their services are falling within the.
Falling.
Yeah, that is what you have already said.
Yes. But
The only point is your argument that there cannot be a public service commission for union territories may be a very dangerous argument because you're conceding ground that look, there can't be a public service commission for a union territory.
unless the parliament permits.
All
Well,
right.
that's
Para
the
25.
constitutional.
Let's see para 25.
And my lord, your lordships, Article 315, which provides for commission, UPSC and the State Public Service Commission, my lord, uses the word governor, not administrator. And this amendment comes simultaneously. It could have said governor or administrator as the case may be. This is constitutional silence. A deliberate silence, when I use the word deliberate silence, because both came under the same amendment, 7th amendment. 315 is also amended. Union territory as a concept is inserted and administrator is defined for the first time by the very same amendment. The amendment made in Article 3154 simultaneously in 7th amendment again inevitably showed that there cannot be any public service commission for any union territory, including Delhi. Having clarified the position that there cannot be any public service commission for union territories, it needs to be pointed out that the function of the Public Service Commission enumerated in Article 323B also makes it further clear, that union territory can have nothing to do with appointments, promotions, and transfers. Please see, functions of the Public Service Commissions. Now it talks of both. The Union Public Service Commission or the State Public Service Commission, as the case may be, shall be consulted on the principles to be followed in making appointments to civil services and posts and in making promotions and transfers from one service to another and on the suitability of candidates for such appointments, promotions or transfers. So on the union and the state. The position becomes further clear from Article 323, which as reflected above omits the term Raj Pramukh and consciously does not include the term administrator while retaining only governor of the state. Article 323 reads as under. Lord, kindly see sub-article 2. I need not read the whole, my lord. Again, the argument is same. Earlier, it was Raj Pramukh. Though union territory came by this very amendment, administrator came by very amendment, it says governor. Raj Pramukh also deleted. And I have given the hierarchy. Part A, Lord Governor, B, Raj Pramukh, C and D, Joint Commissioner. And Delhi, undisputably, till 7th Amendment, was Part C state having a Joint Commissioner. Chief Commissioner. I stand correct. Lord, now there is another.
I'm not interrupting. I'm just saying, because I need my 90 minutes. The Lordship may have to just overflow. Just because I don't want to interrupt you. I'm just saying something which I don't want to compromise on that.
I'm not repeating anything.
Just something.
Fair. The request is fair.
1 hour is now over.
1 hour is over, but I would request.
I'm not saying
Honorable
I'm just
Bench
pointing
to give me. I'll not repeat anything.
All
These
No,
are.
Raj Pramukh, you are repeating.
Let us come to Lord next.
And administrative Raj Pramukh, you are repeating. You proceed administrative.
Lord, now Raj Pramukh will not be uttered by me, Lord.
Raj Pramukhs are a relic of the Raj. Denied anticipatory bill, 10th. Then you say, no, 12th. No, my lord, 10th. So, you have to sort of break the ice and say, okay, come on.
That's the very apt analogy, my lord. That repetition doesn't take yes out of the other person. My lord. Look, another one. Now, completely, my lord, forget now chapter 14. But I come to another limb of my submission. Another indication that persons working in the union territory are working in the affairs of the union. So now administrative tribunal.
I'm sorry, I'm eating into your time, but there's only one aspect, that is 309 gives power to the union government to regulate all terms and conditions of service of officers who are appointed in connection with the affairs of the union. Could it possibly be that, I mean, your argument would be that affairs of the union in Article 309 would mean the entirety of the affairs of the union territory, right? Including all services. The other countervailing argument could be that affairs of the union in Article 309 should include those matters which are entrusted to the union by 239 AA. One way of looking at it is, look, the entirety of the canvas of a union territory of Delhi, notwithstanding 239 AA, is an affair of the union because the union has jurisdiction on list 1, list 2, and list 3.
Therefore,
But that is subject.
Therefore,
It's a little
your
tricky.
lordships have in mind.
309 also subject.
Lord, the lordships have in mind, Lord, a position, Lord, which is
Takes us to
portrayed. Let me demolish, my lord, fully crafted perception that we have no power. Let me demolish that. Then your lordships may examine, my lord, these legal provisions in that context.
Yes.
Lord, para 27. The
Yes.
Administrative Tribunal Act is enacted in exercise of the powers under Article 323A of the Constitution. The said article provides that the Parliament may make law constituting tribunals of disputes and complaints with respect to recruitment and conditions of service of persons appointed to public services and posts in connection with the affairs of the Union and another affairs of the state. Now, my lords, may kindly come to section 14 of the Administrative Tribunals. Jurisdiction, powers and authority of Central Administrative Tribunal. The lordships have, my lord? Page 11. Kindly, my lord, directly come to page 12, the explanation. For those who are acting or functioning in the affairs of the Union, there is a Central Administrative Tribunal. For those who are in the state, there is a State Administrative Tribunal. Page 12, explanation. For the removal of doubts, it is hereby declared that reference to Union in this subsection shall be construed as in territories. It is under this provision that Parliament has made Delhi High Court Act 1966. Article 219, read with Section 4 of the Delhi High Court Act, replaces the word governor with lieutenant governor. Wherever the Parliament wanted, the Parliament has made a provision for governor and lieutenant governor. Please see, my lord. Similarly, Article 230 and 231 also replaces the word governor with administrator. Pertinently, however, parliamentary law of Delhi High Court Act and above quoted constitutional provisions makes it clear that in case of union territories, the Service Commission is only UPSC and none else. Article 241 of the Constitution, Section 4 of the Delhi High Court Act, and Article 219 and 230 and 231 of the Constitution are quoted above. 230, your lordships can not skip. So kindly see 232B. This is for Delhi. Having a union territory, and please see B, 2B. The reference in Article 227 to the governor shall, in relation to any rules, forms, or tables for subordinate courts in that territory, be construed as a reference to the president. Lord, again, though it's union territory, the reference in Article 227 of the governor to the governor shall, in relation to any rules, forms, or tables for subordinate courts in that territory, be construed as a reference to the president. Then your lordship, my lord, kindly see 231, establishment of a common high court for two or more states. This is not for Delhi or any state, but this general provision contained in Part 8. Kindly see the proviso which I have underlined. Provided that if such principal seat is a union territory, there can be a common, my lord, high court for a state and a union territory. Provided that if such principal seat is in the union territory, the references in Article 219 and 229 to the governor, Public Service Commission, legislature, and consolidated fund of the state shall be construed respectively as reference to the president, Union Public Service Commission, Parliament, and consolidated fund of India. Even if the High Court is a joint High Court for state and union territory, merely because the principal seat is in UT, not governor, the president, not state public service commission, UPSC, not state consolidated fund of the state, consolidated fund of the India. Look, there is a threat that there is UT, we don't recognize UT except the powers which are constitutionally ceded, like 239AA.
Yes.
Now, my lord, kindly directly come to page 15. And this is, my lord, the heart of the matter, which which would be troubling your lordship's conscience also, because a very well orchestrated perception is that we don't have any power. What do we do? My learned friend argued that we don't have steering wheel, we don't have gears in our hands, we don't have brake, we don't have clutch. Now kindly see, my lord, in that context, and I'll answer, my lord, that question. At the outset, my lord, para 39, and this is, my lord, kindly see, my lord, there are two types of control. My lord, what the central government is claiming is control for recruitment, appointment, and posting. Nothing else. Rest governance is with the elected wing. And I'll show that. Kindly see. At the outset, it may be pointed out that there is a clear distinction of legislative powers and consequent administrative powers with regard to Union of India and NCT of Delhi. They are functional control and administrative control. Functional control means right to have steering wheel, right to have gears, right to have brake, right to have clutch under their control. So far as the functional control is concerned, it signifies the control of an elected body in its functioning through the officers and employees working in the affairs of the union. That is, day-to-day functioning under the administrative control and supervision of the minister of the concerned department, the Honorable Chief Minister, and the Council of Ministers, that is elected wing. Lord, as my Lord, the Chief Justice of India, Lord, suggested, even in those cases where it is the central end, suppose under 239AA they are entitled, they can function. The officers will be answerable to the Minister, the Honorable Chief Minister, and the Council of Ministers, not to anybody else. Please see. So far as the administrative control is concerned, it would signify the decision as to whom to be posted in affairs of the NCT of Delhi, in which position and post such officers or employees would be posted, transfers to be effected, and disciplinary action to be taken. This control is absolutely necessary since Delhi is the capital and the central control is not only desirable but constitutionally permitted without in any way interfering with the absolute functional control of the elected wing. In case of NCT of Delhi, as explained hereunder in detail, the functional control vests in the elected wing and all officers, employees are required to function under the administrative control and supervision of the elected wing and implementing the programs and policies of the elected wing, which would reflect the wish and will of the electorate, while the administrative control is vested both constitutionally and other in the president and under the order of the president, kindly allow me to, my lord, mail, who exercises the same through the lieutenant governor. So far as the control is concerned, almost a fiction is created by way of a public perception that they have absolutely no control of the elected government over the officers and employees working in GNCPD. This fictional perception and far from truth, which will become evident from the following paragraphs. Lord, kindly see, in conformity, Lord, your lordships can skip 44. Lord, I'm not taking your lordship's time. Crucial is 45 onwards.
Mr. Mehta, to be on the absolute lighter side, nothing to do. When you said that functional powers and the administrative powers and the driving seat, correct, clutch, everything visit them. But according to them, correct, the direction, like GPS, correct, the direction where to go, left side, it is with the central government.
Lord, after reading, Lord,
That is what, this is distinction between the administrative power and the functional power.
No.
Correct.
I'll, my lord, respect.
Suppose according to them, if they want to go straight, they cannot go because of the administrative power, because the direction will be go right side or left side.
Lord, after going through this,
Absolute lighter, nothing.
I know. Lord. Sometimes it's good, my lord, to have lighter moments. Lord, after going through this, I can say this, my lord, in this very simile, Dr. Singhvi said, they have the steering wheel, they have the gears, they have the clutch, they have the brake, they decide the direction also. Only the make of tires, whether MRF or CEAT, is done by the LG. And if still you cannot drive, then there is something seriously wrong with your driving ability, not with selection of tires.
But you know, Mr. Mehta, actually, see, as we know in the states, for instance, the most important part is where do you post an officer, right? Whether an officer will be in Secretary Finance, Secretary Home, Secretary Education, Secretary Environment, Secretary Youth Affairs or Sports,
Etc.
So what you are saying is that, look, we will post you as Secretary Finance. Once you are posted as Secretary Finance, you will act under the jurisdiction of the Minister of Finance. We will post you as Secretary Education. Then you will be reportable to. You will report only to the Secretary, to the Minister for Education and the Delhi government. But suppose they find that somebody is not really up to, not functioning as effectively as in that particular role. Your contentions, of course, Dr. Singhvi also conceded that we are not disciplinary jurisdiction. But they cannot even switch officers.
They can. I'll answer your lordship's question. And my lord, kindly park that question till your lordship goes through this. I'm saying this with a sense of responsibility. They can always say that this man is not fit for the health ministry, post it in industries ministry. They have to send a letter through LG to the MHA, and it is never refused.
That's a matter of, that's a matter of accommodation in practice.
Kindly, my lord,
Otherwise, look at it from
that
this way.
question. Kindly park.
An officer knows that, well, I cannot be moved out from this position at all. I cannot be moved out as an excise commissioner, however I do, unless I have a green signal from MHA.
Kindly, my lord, kindly
I'm not
park
really,
that.
whatever I do as an excise commissioner, what I will do as a Secretary Education,
Unfortunately,
unless I have the green signal, I will never be moved out.
unfortunately,
Will that not dilute even the functional control? That's the point. Yes, recruitment, disciplinary control. You're right. Absolutely. Dr. Singhvi, in fact, didn't go as far as that when he made a very nuanced.
I hope, my lord, these are tentative
about
observations.
posting.
Subject.
Question is about posting. You see that?
Lord, sometimes a wrong perception repeated and carefully orchestrated through various mediums, Lord, have the tendency of entering our minds. Lord, the following paragraphs
All right, quickly, let's read it.
are devoted my lord, to
Read it.
Para 45.
45.
And my lord, why this is relevant and why your lordship may park that, my lord, apprehension, tentative apprehension, till your lordship, my lord, goes through.
All right, let's quickly read that para 40.
First, All India service officers, TENIC officers and all other officers working for GNCTD are under the functional control of Minister concerned, the Honorable Chief Minister and GNCTD and Council of Ministers as pointed out hereunder. Secondly, for any officer, the most important element of his service is career progression in terms of promotion, which is based upon the annual performance appraisal report. Please don't make any conclusion till I take your lordship through this fully. Any adverse entry in APA, that is annual performance appraisal, is capable of spoiling his chances of promotion and his future career progression. So far as all senior and middle level officers are concerned, who are under the functional control of the elected government and through whom the will and wish of the electorate in terms of the programs and policies of the governments are to be implemented, their APAR are under direction, control of the Honorable Chief Minister of Delhi, either as reporting authority, reviewing authority, or accepting authority. In other words, depending upon the functions of each senior level and middle level officers under the supervision and control of the ministers of each department, which includes right from secretary, chief secretary, etc., right from secretary downwards. The Honorable Chief Minister can give suitable grades which will have a direct bearing on his future career progression. APAR consists of annual work plan to be decided twice a year. Now, this answers your lordship's question. That is, once at the start of the financial year and secondly by way of a mid-year review. The assessment of officers in APAR is done on following attributes. This the elected wing does. Assessment of work output. The lordship would have said efficiency. This man should be efficient in this field and not in that field. Kindly see, it consists of following sub-attributes. Accomplishment of planned work, quality of output, accomplishment of exceptional work or unforeseen task performance. Then second, the 30% weighted, assessment of personal attributes. It consists of following sub-attributes: attitude to work, sense of responsibility, overall bearing and personality, emotional stability, communication skills, moral courage and willingness to take a professional stand, leadership qualities, captaincy to work in time limit, capacity to work in time limit. Then third, 30%. Assessment of functional competency. It consists of following sub-attributes: knowledge of laws, rules, procedures, IT skills, and awareness of local norms in the relevant area. Strategic planning ability, decision-making ability, initiative, coordination ability, ability to motivate and develop subordinates or work in a team. All these attributes are decided and gradation is given by the Honorable Chief Minister. Kindly report further. It is submitted that Honorable CM appraised the performance of officers of GNCTD through the mechanism of APAR, wherein the performance of officers of the GNCTD is evaluated by the CM, i.e. elected government, on a scale of 0, that is worst, to 10, best. And also a pen picture on conduct of these officers are recorded in writing by the Honorable CM in these APARs. I, as an officer, cannot say that I owe my allegiance to MHA. I will not take orders from you because he is the one who is writing my annual performance appraisal reports. In the last 3 years, that is 2019-20, 2021, 21-22, the Honorable CM had appreciated the work of all IAS officers, principal secretaries, secretaries and heads of the department working in GNCTD and accorded them outstanding rating. Grading from 8 and above is outstanding, not out of 10. To all officers except one officer wherein very good grading was given to such officer for the year 2019 to 20. Even this officer has been graded as an outstanding officer for the year 2021 and 21-22 by the Honorable CM. Details of Honorable CM. Details of which are mentioned in a, kindly come to page 43. For my satisfaction, please come to page 43. But if I am not working satisfactorily, if I am not fit for that particular post, if I am not listening to the ministers, if I am not discharging my functions properly, if I say that I owe my allegiance somewhere else, then it directly reflects on my APR, which is not to be written by the central government or even by the LG. Kindly see page 43. I will not read everything, just have a glance. Mr. So-and-so, ACS Power, grading 10 out of 10. So-and-so, ACS, UD and Director, local bodies, 10 out of 10. Then 9, 9.5, 8, 9.50, 9.80, 8.50, etc., etc. Not everyone. Kindly come to 45. Look, this is the next year, 2021. These are the people working under their supervision, under their control, under their administration, discharging the duties given by them, and they judge them. Lord, please see 9, 9.5, 9.5, 8.
Between Mullah's pleadings and written submissions seems to have been obliterated. My learned friend's repeated saying about not going into facts seems to have been obliterated.
No, this is
Written
a
submissions are having facts, no pleadings, and your lordship is to be drawn in, whether in a lighter vein, not so light vein. Whereas our allegation is central government is trying to swallow our powers. What is happening today is my entire morning time is going to be swallowed by my learned.
Lord, I would, my Lord, give one full, many credits to Dr. Singhvi, but today, right now, one credit, he interjected at a right time from his point of view. This was the time where he should have interjected and derailed the argument.
Solicitor.
I refuse to be derailed.
So, Solicitor, I remember one day when Dr. Singhvi, with his characteristic flourish, came in the morning for mentioning matters before Justice Narasimha and me and said, I'm filing an affidavit. Please ask the solicitor.
Your lordship refused.
We refused that. We said, we're not going to go into
And repeatedly he's protesting that I will not do it.
All right, but we are not going to be impacted by it. He just sort of said that
That's all right.
individual
This also is taken.
individual gradings.
Your lordship-
They can refuse that this is a false figure.
But Mr. Solicitor, we got your basic, we'll look at it at a doctrinal level that the APARs are written by the Chief Minister. You may make that limited point. Let's not go into
Kindly, my Lord, come to page.
Anyway, you want to point out
because then we
that the
have a whole
apprehension,
lot of material in the joint
your submission is that apprehension is not well founded, correct? That though officers are not properly working, correct, nothing can be done. That is what your submission.
Yes, I'm respectful. I'm
because
grateful.
ultimately you say
And
the
another
submission is done by the Chief Minister.
No, nothing inconvenient will come.
No,
You can sit down.
I'm saying nothing, I'm just.
No, you
telling
rightly
You're the one who's
got up.
speaking.
Lord, another thing. Lord, I'm answering your lordship's apprehension that what if the person is not fit for that job? Then, my Lord, kindly see page 47. This is not facts. This is a format, standard format. Standard format. What is the matter in which, my Lord, what are the issues on which he is to be judged by the
In the APRs, right? Annual performance. All right, now let's go on to the next point, Mr.
that not
Now-
fit, not
All right, we'll now go
not
on to
fit for
para.
this job,
We've
etc.,
got-
etc., not competent.
Now let's read para 59. That's the next point. I think this point we have covered now.
Yes.
Para 59, Constitution and Statutory Scheme Governing Services. This is what you were showing us last time when we closed on Thursday.
Yes.
Let's look at that now.
But your lordships have, my Lord, kindly, my Lord, now come. My Lord, your lordships have still in mind that what will they do if you don't have any control? So therefore, just to show that the steering, clutch, gear, brake, direction is theirs.
All right, we'll see whether what
Yes.
they have and what.
There is something, my Lord,
Anyway,
seriously wrong if they say we can't function.
Para 59, let's get on.
Yes.
Para 59 now. है ना?
Lord,
That's the last.
one year of.
What you can do, solicitor, is you have already divided into subheadings. Take each of us, we will go through each of them. You tell us broadly the gist of what you are saying and you can make your argument on that in each of those from 59 onwards.
Lord,
Para
51, your lordship.
59 is the constitutional scheme that you are talking
No,
about.
no, Lord, 51, my Lord, if your lordship.
Okay.
How, Lord, the president has made, my Lord, the transaction of business rules, how the officers will follow, will work.
All right. That
That
according
is
to
a
that,
direct bearing, my
that
Lord, on
TBR shows that they work actually under the minister concerned.
concern, my Lord. And he judges their competence, ability, leadership quality, sincerity, etc., etc. My Lord, there are several attributes. The council shall be collectively responsible for all the execution orders issued by any department in the name of Lieutenant Governor and contracts made in the name of the President in connection with the administration of the capital, whether such orders or contracts are authorized or not. And 2, without prejudice to the provisions of Sub-Rule 1, the minister in charge of the department shall be primarily responsible for disposal of business pertaining to that power that you have the power to do. 14. The decision of council relating to each proposal shall be separately recorded and after approval by the chief minister or the minister presiding shall be placed with the record of the proposal. After approval of the chief minister or the minister presiding, the decision of the council as approved shall be forwarded to the secretary, by the secretary to the council, to the lieutenant governor. My lord, that is for sub-article 4. Differ and refer. 2. My lord, I am giving facts, my lord, because I have chosen not to give facts through media. The media carried an article that out of 7, I'm sorry, my lord, kindly, I'm making this with a sense
Yes,
of
yes.
responsibility.
Yes.
That out of 7 difference, 5 are in this regime. My lord, I am ready to place before your lordships what were the differences.
Seven difference.
Which
Lord,
were,
I said that from,
Oh, okay.
which were referred to the president.
my lord, that right from, my lord, 2012 till date, 18,000 files came for differ and refer power. 18,000 file clear, nothing, my lord, it's just, my lord, files. Only 7 times the LG differ, 12 till date. 5 times, according to them, during this regime. That is true. That's a fact. They could not bring it by way of an affidavit. It came by way of a news item, which I avoided doing. But if your lordship wants to be satisfied that intervention, differing and reference to precedent was a mandate, I am ready to place the files before your lordship. So thereby the file goes to the LG for that power of differ and refer, not for anything. Where a proposal has been approved by the council and approved, record of the decision has been communicated to the LG, the minister concerned shall take necessary action to give effect to the decision. That again minister will take that and direct the secretaries and his staff. If the department concerned are not in agreement regarding such a proposal, the minister in charge of any of the department may, if he wishes to proceed with the proposal, direct that the proposal be submitted to chief minister for order or direction or for laying it before the council. There are internal disputes, there can be 2 ministries involved, there may be difference of views. Then it goes to the honorable chief minister and if necessary to the council. 15. Except as otherwise provided by or under these rules, proposals or matters may be disposed of by or under the authority of the minister in charge, who may, by means of standing orders, give such directions as he thinks fit for the disposal of proposals or matters in his department. Copies of such standing orders shall be forwarded to the LG and the chief minister, provided that such standing orders shall not relate to the statutory powers conferred under any law upon the officials. There are some revisional powers, etc., given to the secretaries under various laws. Obviously, there can be standing orders that are quasi-judicial powers. Then 16, minister shall by means of standing orders arrange with the secretary of the department what matters or classes of matters are to be brought to his personal notice. Your lordship knows, but not entire nation, all files do not go to the ministers, whether it's union, state or union territory. But minister can say that these files will have to be given to me for my personal. Otherwise, it is rooted within the administrative, bureaucratic hierarchy. Copies of such standing orders shall be forwarded to the LG and the chief minister. Every Monday, or if it is a holiday on the next working day, the secretary shall submit to the minister in charge a statement showing the particulars of important proposals or matters disposed of in the department by the minister and the secretary and other officers during the preceding week. A copy of the said statement shall be simultaneously submitted to the lieutenant governor and the chief minister. Thus, the functional control for undertaking the governmental business lies absolutely with the minister concerned, and for this purpose, concerned IAS officers and all other officers report to the minister concerned. Lieutenant governor has no role except constitutionally provided under Article 239AA4. Differ and differ. In case of IAS officers does not follow the provisions of TOBR, then he is liable for disciplinary action for violation of provisions of Rule 3 of All India Service Conduct Rules. You immediately bring it to the notice of the MHA. This is what it is to happen. That's the scheme. That's the scheme of the Constitution and scheme of the rules, service rules, that this man is not behaving properly with me. You take departmental action. Then 53. it is submitted that if any minister concerned finds that an IAS officer or any other officer is violating provisions of TOBR or any conduct rules, he may report it to the disciplinary authority, that is MHA, through Lieutenant Governor, as undisputably the disciplinary authority is MHA. While the appellant is making claims using hypothetical situations that the elected government would not be able to implement its policy without having control over transfer and posting of the officers, the above mentioned TBR, my lord, 55, your lordships can, my lord, ignore, kindly come to 56. So there is one more check. 56. My lord, kindly bear with me, my lord, this is not a matter where, my lord, your lordships are deciding about the capital of the nation, my lord. So I would be failing in my duty, my lord, if I curtail something which I think it to be relevant and appropriate for your lordship's assistance.
No, that is why, Mr. Mehta, we are hearing you and listening you.
No, your lordship. I'm grateful.
Otherwise,
I'm
despite your 1 hour has already gone, we are just listening because very important matter is there. Therefore,
I'm grateful.
but still you have to consider that
And
time
extending.
constraint.
I'm skipping what is not relevant or what is repetition. I'm skipping. It is most respectfully submitted that apart from the above referred legal position showing services falling within the domain of Lieutenant Governor, the Honorable Supreme Court, with its judgment dated so-and-so and writ petition so-and-so as directed, constitution of a civil service board consisting of Chief Secretary and other high-ranking officers. In case of Delhi, CSP consists of Chief Secretary, the second senior-most IAS officer in GNCTD, and Secretary Services, not again GNCTD. GNCTD to guide and advise with regard to transfers and posting, etc., to the Lieutenant Governor. The Lieutenant Governor decides the transfers and postings of all India service officers on the basis of recommendations made by the CSP. Lord, I have annexed the copy. The following framework ensures check and balances in the system to administer the capital wherein disciplinary control lies with the MHA, transfer and postings lies with Lieutenant Governor, and functional control lies with the. Look, this is the harmonious balance with the Constitution and the service rules have provided for. And it is operating since 1992, which now my learned friend wants to change without showing under which authority of the Constitution he has the power. Now, my lord, kindly see, kindly come to, my lord, 62. The above referred three categories of central services are the categories for the entire country. So far as Delhi is concerned, its administrative setup is as per the following hierarchy. So, Chief Secretary, then Additional Chief Secretary or Principal Secretaries and Secretaries, then DENIC officers and DAS officers. So, this is the broad administrative hierarchy. Now, kindly see, the provisions. So, this is again the heart of the matter. How the central government constitutionally and as per statute, empowered for recruitment, posting, transfers, etc. Lord, your lordships have seen 239(1). Article 239(1). Lord, I am not reading it. Please read, my lord, Rule 46 of Transaction of Business Rules, Lord, framed by the Honorable President. Lord, there are blanks, my lord, para. I will fill it, my lord. It's there already in the, my lord, paper book. With respect to persons serving in connection with the administration of NCT, the Lieutenant Governor shall exercise such powers and perform such functions as may be entrusted to him under the provisions of the rules and orders regulating the conditions of service of such persons or by any other order of the President in consultation with the Chief Minister, if it is so provided under any order issued by the President under Article 239 of the Constitution. My lord, kindly mark one thing. There is a provision made by the President which empowers the Lieutenant Governor with regard to transfer postings, etc. And if there is any provision which requires him to consult the Honorable Chief Minister, he will consult the Honorable Chief Minister. But bear one fact in mind, there is one direction or order of the President in the form of TOBR, because something would turn when I show the scheme of the GNCTD. Notwithstanding anything contained in Sub-Rule 1, the Lieutenant Governor shall consult the UPSC on all matters on which the Commission is required to be consulted under Clause 3 of Article 320, and in every such case he shall not make any order otherwise than in accordance with the advice.
We'll take a just take a comfort break for 5 minutes. We'll be back in 5 minutes.
Please.
Both.
Yes, sir. Your lordships have both the controls. There is no dispute.
Mr. Solicitor, this was not time out for you, huh? So this is included in your time.
The deduction will not be permitted. This is
No deduction
possible
permitted.
No, my lord, I am confident of your lord.
Yes.
Magnanimity and majesty, my lord. Lord, Lord, now few pages, but they are very, very relevant.
All right.
And would answer your lordship's query.
Now that next part you can read now.
Yes, Lord. Lord, your lordships have seen Rule 46
Yes.
empowers the LG to act as per his discretion. Lord, if President provides consultation, with consultation, otherwise without consultation. Lord, now kindly see Rule 57 of these very rules made by the President at page 24. the chief secretary and the secretary of the department concerned are severally responsible for the careful observance of these rules, and when either of them considers that there has been any material, instead of giving effect to such departure, he shall personally bring it to the notice of minister in charge, chief minister, and the lieutenant governor. There is a mandate that this functional autonomy of the elected wing will have to be complied with. If there is any deviation by anyone, he is personally responsible to bring it to the notice. Now, my lords, may kindly see, my lord, under Article 239AA 7, my lord, please see, my lord, for a second, 239AA 7. There is an act made, my lord, and I am relying upon 2-3 provisions of that act, which I have not, my lord, argued earlier. 239AA, sub-article 7. Your lordship says that the parliament may, by law, make provision or supplementing the provisions contained in all matters incidental or consequential thereto, and B, any such law as is referred to in subclause A shall not be deemed to be an amendment of this constitution for the purposes of Article 368, notwithstanding that it contains any provision which amends or has the effect of amending this constitution.
It's like the Article 4, similar to Article 4.
Yes, my lord, but even 239AA can be, my lord, varied or changed or modified in exercise of this power. Lord, it's an extraordinary power because it's a union territory. Otherwise, my lord, as I have said, such wide powers are not found anywhere in the constitution. Now, in exercise of this power, my lord, the GNCTD Act is enacted by the Parliament. And please see section 41 of the GNCTD Act.
That is at page.
Yes, my lord, when Dr. Singhvi read this,
20.
he read only 2 and missed 1. And your lordship would realize why, from his point of view, my lord, the right thing. Matters in which Lieutenant Governor to act in his discretion. The Lieutenant Governor shall act in his discretion in a matter, 1, which falls outside the purview of the powers conferred on the Legislative Assembly, but in respect of which powers or functions are entrusted or delegated to him by the President. But I am linking this with Rule 46, a direction of the President which empowers him to act as per his own discretion and not as per the aid and advice of the Council of Ministers. And here,
No, but 46 also says he will exercise such powers and perform such functions as may be entrusted to him under the provisions of the rules. And under the provisions of the rules and orders regulating the conditions of service of such persons. So if the Article 309 rule gives powers to the LG, then he can exercise those powers.
I bow down. The rules are coming further. Now, please see 49. Relation of Lieutenant Governor and his ministers to President. Notwithstanding anything in this Act, the Lieutenant Governor and his Council of Ministers shall be under the general control of and comply with such particular directions, if any, as may from time to time be given by the President. And my lord, my crucial submission for your lordship's consideration is that the notification dated 21st of May 2015, that services will be Lieutenant Governor's discretion, is direction of the President in exercise of this power, read with Rule 46. The notification dated 21st May is in fact and in substance the delegation of power by the Honorable President in exercise of the powers under Article 239. Lord, Article 239, my lord, kindly do not forget Article 239, which says the President shall administer union territory, either himself or through administrator. So that is first power of delegation. This is, my lord, that delegation, read with section 41 and 49 of the GNCTD Act. My lord, it was read before your lordships and it gives an impression as if there is an amendment made. Your lordships would not go by the language used or your lordship would examine the substance of the notification, not the form. The form, the direction says that this is the entry which will be governed by the lieutenant governor. It has always been governed. And since there was a dispute, the president, my lord, thought it fit to issue this direction, my lord, which is traceable under 41 and 49 of the Act. Now, my lord, kindly see the statutory provisions. Directly answering, my lord, the Chief Justice's question, service law. What is the service rules? What it provides? It is submitted that All India Services under All India Services Act are Central Services Group A at the national level as contemplated under Article 312. It is submitted that the recruitment to Group A services is made by UPSC. My lord, I may skip that. Your lordship knows, my lord, the UPSC conducts exam for various services. Marks are given, IAS, IPS, IFS, IRS, economic services, etc., my lord. That I can skip, my lord. Kindly, my lord, now come to para 70. Para 71, I'm sorry, para 71. The Group A, All India Services, is central services, get their respective cadre under the All India Services Act, read with All India Services Cadre Rules, 1954. It's already there on record, but the relevant part, which is relevant, I have already quoted. So far as the states are concerned, not the union territories, the officers of All India Services are allotted for each state. Lord, your lordship knows their cadre is determined. If I am selected in IAS, I can choose Gujarat as a cadre if my marks so permits, or if my marks do not permit me, I will get any cadre which is left over. So far as union territories are concerned, which are, this may kindly be not examined irrespective of the time constraint, because this would be the heart of the matter, my lord. Again, this matter has more than one heart, my lord. I repeated it thrice, therefore, my lord, this is the third heart of the matter, my lord. My apologies to your lordship. So far as UTs are concerned, which are directly controlled by the Union of India and not by any state, to All India Services. The first important rule in All India Services cadre rules, the definition clause are relevant. Lord, please see, my lord, the definition clause of cadre rules. Cadre officer means a member of Indian Administrative Service. My lord, the top bracket in GNC, heads of the department. Cadre post means any of the posts specified under item 1 of each cadre in schedule to the Indian Administrative Service fixation of cadre strength regulations. Your lordships are not concerned.
Yes.
Lord, this is crucial, Lord. There are two definitions. One is state. State means a state specified in the first schedule to the Constitution and includes union territory. D. State government concern in relation to a joint cadre means the joint cadre authority. So there are two expressions, state and state government concern, both separately defined. State means state, includes union territory, and state government concern means joint cadre, because I will show what the joint cadre is. The constitution of cadres is provided for in Rule 3, which reads as under, there shall be constituted for each state or group of states an Indian Administrative Service cadre. The cadre so constituted for a state or a group of states is hereinafter referred to as state cadre, or as the case may be, a joint cadre. More than one state. Correct? From the conjoint reading of the aforesaid provision, it becomes clear that there are two concepts, state and state government concerns. Kindly, my lord, come to the next page, 28. So far as postings of All India officers are concerned, there is a specific provision in statutory rules, namely Rule 7, which reads as under, all appointments to the cadre post shall be made in case of a state cadre by the state government. When there is a full-fledged state, I am allotted a Maharashtra cadre, then by the Maharashtra government. B. In case of a joint cadre by the state government concerned. Please, my lord, note here and my lord, park it. Rest may not be relevant for your lordship's consideration. I have quoted so that I am not accused of not selectively quoting. 78. The provision based upon which some confusion is created is a provision contained in Rule 11A, which reads as an authority to exercise certain powers in respect of members of the service serving in connection with the affairs of the state, constituting a joint cadre. The powers of the state government under the second proviso to sub-rule 2 of Rule 4 under clause so-and-so, so-and-so, so-and-so and Rule 7. We are concerned with Rule 7, which provides for posting. In relation to members of services serving in connection with the affairs of any constituent states shall be exercised by the government of that state. Correct, Manoj? Now please read further. How, my lord, this is to be read harmoniously. Your lordships have, my lord, seen that any definition clause starts with except the context otherwise requires. Unless the context which I am giving is accepted, 7 and 11A would be in contradiction, distinction to each other, which can never be, my lord, the intention. Please, it is submitted that a literal and out of context reading of 11A is capable of creating a confusion that Rule 11A and Rule 7 contained in very same rules are in contradiction to each other. At the outset, it is submitted that the word joint cadre in Rule 11A is in right context used as a joint cadre of two full-fledged states without any union territory. And I'll read it 11A again. In Rule 11A, the word state is not used as defined under Rule 2C, which itself starts with unless the context otherwise requires. Rule 11A applies when there is a joint cadre of more than one full-fledged states. In such a case, the power under Rule 7 would be exercised by the government of each constituent state. But Assam and Meghalaya has a joint cadre. Then Assam will decide Assam officers, Meghalaya will decide Meghalaya officers. And there is a history behind it. Lord, please note, 11A was inserted subsequently after 1972. And that will make it clear that 11A is not in contradiction to 7. It says when two or more full-fledged states create a joint cadre, then 11A will apply. Lord, kindly allow me to show that history, Manoj. The provisions of Section 11A was introduced on 11 January 72 as a separate state of Meghalaya, but Manoj, this bifurcation happened. Had joint cadre then and continues to have a joint cadre even now. In other words, Rule 11A is not in conflict with Rule 7, and in both the rules, the term state would mean full-fledged states. When there is a joint cadre with some union territories also included in the joint cadre, the posting would be made by the state government concerned. Lord, 7B, your lordship would recall. As stipulated in 7B, as noticed earlier, the power of posting is vested in state government concerned under Rule 7 of the Indian Administrative Service Cadre Rules. The term state government concerned is defined in Rule 2D of the said rules, which means joint cadre authority. Lord, kindly pause here for a minute and minutely see, Lord, 11A doesn't use the word state government concerned. It says by the state, respective state. Lord, therefore, the intention is, in view of the historical background, that when there are two or more full-fledged states having a joint cadre, then the state government concerned will decide. Their state would not include union territory. As noticed earlier, I'm sorry, my lord, 85. For this purpose, now, my lord, who is, your lordships have seen, state government concern means joint cadre authority. Now, who is the joint cadre authority? For this purpose, it is necessary to go to All India Services Joint Cadre Rules, which are statutory rules. Rule 1-2 reads as under They shall apply to joint cadre constituted for any group of states other than joint cadre of union territories. Lord, kindly mark this. Something may turn on this. Then definitions. In these rules, unless the context otherwise requires, joint cadre authority means the committee of representatives referred to in Rule 4. And constituent states would mean states in respect of which a joint cadre is formed. That is the states. These are the rules made in 72 itself. Your Lordship would notice this. At this juncture, a little history as to why All India Service Joint Cadre rules were required to be formulated and why they were formulated may be relevant. The Joint Cadre rules were framed when there was one service for all union territories, that is pre-Egmont era. All union territories were clubbed together before 72. This is the reason why Rule 1.2 excludes joint cadre of union territories. When the joint cadre of only one union territory was in existence, the joint cadre authority was Ministry of Home Affairs for all union territories under the Government of India Allocation of Business Rules 1961, which are made in exercise of powers under Article 77 of the Constitution of India. The relevant part reads as under, my lord. Kindly read, my lord, the highlight, the underlying portion. This is for union territories. Then union territory with legislature. There is a detail, my lord, without legislature, with legislature. We are concerned with legislature and that too NCT. There is a separate provision. These are constitutional rules. Lord, I will not read, but I will cite a judgment that rules made by the president have the statutory force. It's having the force of a statute, not just statutory rules. All matters falling within the purview of the union government in terms of provisions contained in Part 8 of the Constitution, insofar as these are applicable to National Capital Territory of Delhi and the Government National Capital Territory of Delhi Act, excepting matters with respect to entry 18 of the state list, and all such matters as have been specifically assigned under these rules to any other ministry or department of the Government of India. Kindly come to D, page 31. General questions relating to public services in the union territories and service matters insofar as these fall within the purview of the state government relating to officers of Indian Administrative Service and Indian Police Service serving in connection with affairs of the union territories. All service matters under the rules framed by the President under Article 73. Then NCT of Delhi, Andaman and Nicobar Islands, Lakshadweep, Daman and Diu, Dadra and Nagar Haveli services, that is DENIS, and Puducherry Civil and Police Services, etc. This is how these rules have been understood and applied by the Government of India. Right from inception, this is how these rules are applied. The Joint Cadre Authority for All India Service Officers in cadres having union territories is MH. Now kindly see further. Till the year 1987, the following union territories were having a joint cadre. Lord, kindly read this. Arunachal was a joint cadre, was a UT. Goa was a UT. Mizoram was UT. And rest, even today are UT. Correct? I'm not reading. Out of the aforesaid union territories comprising of union territory cadre, that is post-Egmont era, the following three union territories became full-fledged states in the year 1987 itself. That is Arunachal Pradesh, Goa and Mizoram. As a consequence of 3 out of the 10 union territories having joint cadre becoming states, the central government was required to take a decision about the treatment to be given to this newly emerged joint cadre, as a result of which a separate cadre was reconstituted, which came to be known as Egmont cadre, which consisted of 3 newly become states carved out of the union territories with remaining union territories. So 3 states, it was a hybrid kind of a cadre, 3 states and 7 units, which continues till date with addition of Jammu, Kashmir and Ladakh now. The Joint Cadre Authority, however, continued to be the Ministry of Home Affairs, Government of India, followed under the rules made by the President, which I read. it is submitted that prior to the creation of Aghmut cadre, all functions of the cadre controlling authority, that is state government concerned, under Rule 2D, referred above was being exercised by the Joint Cadre Authority, which was constituted with a notification dated 3/4/89, a copy of which is annexed herewith and marked as Annexure D. My Lord, if your lordships can, my lord, allow me to read that. That's already a part of the record, but it is, my lord, this is the quotation. Yes. 71. Page 17. I'm sorry. This is a part of my earlier document, but adjustment of states concerned hereby constitute the Joint Cadre Authority. Of states concerned hereby constitute the Joint Cadre Authority for joint IAS, IPS, IFS cadre of Arunachal Pradesh, please mark, my lord, Goa, Mizoram, and Union Territories as below. This is pre-Aghmut. Chief Secretary Arunachal Pradesh, Chief Secretary Goa, Chief Secretary Mizoram, Additional Secretary in the Ministry of Home Affairs in charge of UTS Division, and Joint Secretary UT in the Ministry of Home Affairs. Yes. This was, my lord, pre-Aghmut position. Now kindly, my lord, come back to page 32. Are your lordships with me at page 32?
Yes.
Para 92. After the aforesaid change, the Joint Cadre Authority held its meeting in October 1988. The resolution passed and decision taken at page 137-139 of Convenience Compilation Volume 4. However, for ready reference, the relevant parties reproduce here. The resolution passed is on page so change. Lord, kindly see these minutes. And Lord, this will connect the dots. How Lord, the Union of India became the Joint Cadre Authority for postings, transfers, etc., etc. Now, Lord, that 4-member committee deliberated and passed this resolution. This was a Joint Cadre Authority then. Prior to reorganization of the UT cadre as a new joint cadre of the IAS, IPS known as Aghmut cadre, all functions of the cadre authority as well as of state, as defined in various rules, regulations governing the terms and conditions of all India services were being looked after by the Ministry of Home Affairs. However, the attainment of statehood, after attainment of statehood by some of the union territories and consequently after reorganization of the cadre, the government has notified the constitution of Joint Cadre Authority for the Joint Cadre with a notification dated so and so, which I read, thus bringing the Joint Cadre within the ambit of All India Services Joint Cadre Rules as amended from time to time in addition to other service rules. In the interest of proper management and smooth functioning of the Joint Cadre within the 4 constituent units of the cadre, namely Arunachal, Goa, Mizoram and Union Territories, it has become imperative that the Joint Cadre delegated some of its routine functions to and authorize the Ministry of Home Affairs within bracket UT Division and other constituent units to exercise those functions and powers, though within the policy framework as determined by the Joint Cadre Authority from time to time. JCA has given a serious thought to the above proposal. JCA has pointed out above, in the interest of cadre management, strongly feels that service matters of local nature, which do not have any adverse impact on the overall structure of the services or the cadre as such, should be dealt with by the constituent units at their own level, as it may not be practicable or desirable for the Joint Cadre Authority to go into these matters in detail. Now, my lord, the delegation comes. Functions to remain with MH, UT Division. Transfer postings of cadre officers from one segment to another. However, for this purpose, JCA will frame proper guidelines, keeping the overall interest of the service officers as well as the constituent units in view. Till the new guidelines are framed by the JCA, transfer postings from so-and-so will be guided by the guidelines as existing on the day. Then, my lord, kindly, my lord, skip and come to page 93. Para 93, I'm sorry. It is submitted that this is how the Ministry of Home Affairs continues to remain the joint cadre authority. These rules are not under challenge. Cadre rules are not under challenge. Joint cadre rules are not under challenge. No act is under challenge. In the context of the above referred statutory scheme, it is necessarily for the GNCTD to show to this court as to how it is the cadre controlling authority or joint cadre authority which can exercise any powers over All India service officers under Rule 7B of All India cadre rules. But I am showing something which they have not been able to show while asserting a particular constitutional proposition. At this juncture, it is relevant to note that President of India had already delegated. Now, your Lordship would have the question, why, how LG comes? Well, this is the answer. At this juncture, it is relevant to note that the President of India had already delegated all powers relating to services of union territories to the administrator, that is Lieutenant Governor, with a notification dated 59, which is superseded by the notification dated 24th September 1998, which is a part of the record note I have just quoted for ready reference. In pursuance to the powers conferred under Clause 1 of Article 239 of the Constitution, the President hereby directs that I'm sorry, kindly correct it. My apologies. The President hereby directs that subject to his control and until further orders, the Lieutenant Governor of National Capital Territory of Delhi shall, in respect of the matters connected with public order, police and services, exercise the power and discharge the functions of the central government to the extent delegated from time to time to him by the President in consultation with the Chief Minister of the National Capital Territory of Delhi, except those cases where, for reasons to be recorded in writing, he does not consider it expedient to do so. This is how the LG comes into the picture. This came to be substituted by the impugned notification. There was already this notification, my lord, in the year 1990. This is now further clarified in the impugned notification. Now, my lord, so my lord, I am clearing the ground for all India services. IAS, that they head the department. Now, kindly see DENIC services, the second tier of administrative setup. There are 33 services which are part of Group B Central Services. Amongst these 33 group services mentioned at serial number 28 and 29 provide for services for combined union territories, namely Delhi, Andaman Nicobar, Lakshadweep, Daman and Diu, Dadra and Nagar Haveli, they called DENICs. Officers are, police are DENICs, but we are not concerned, police is not with them. That subject is not with them. It is submitted that DENIC service is a feeder cadre for all India services, namely Indian Administrative Service. In other words, the DENIC officers can be promoted to Indian Administrative Services, promoted to. There are many DENIC officers who work as special secretaries in Delhi, other union territories which are governed by DENIC rules. All of them are union government officers working for the affairs of the union. Well, then I'll say they are selected by UPSC in page 98, which I'll skip. Then, my lord, kindly come to 100. It is submitted that National Capital Territory of Delhi, so and so DENIC Service Rules 2003 are made by the President of India. Lord, my lord, the Chief Justice's question in 41. Then which are those rules? Chief Justice of India. President of India, in exercise of powers conferred by the proviso to Article 309 of the Constitution, the relevant provisions are mentioned in definition clause so and so. Administration means the government of National Capital Territory of Delhi in respect of national so and so. Administrator means the administrator appointed under Article 239 of the Constitution for union territories of so and so as the case may be. Lord, here administrator we read LG. Appointing authority, my lord, please note this and my lord, highlight this. Can't be highlighted, my lord, in digital version, my lord. Otherwise we...
No, it can be helpful.
It can be.
I'm sorry, my lord, I'm sorry, my lord. Not because of your lordships, due to your lordships.
No, it is good that you have got the admission.
Yes, I got that.
KG or no KG?
My judicial clerk told me, she told me just 2 days back that you use the preview option. If you use the preview option, then you'll be able to highlight. If you're using the Adobe version, sometimes there's a problem in highlighting in some of these PDF files.
No, we use liquid text. But I do not
Oh, you're not working on a Mac. But just see, you'll be able to, even on liquid text, I haven't used liquid text, but I'm sure you have a highlight option.
both have the option.
Yes, there is.
There they are.
There is.
Yes, okay.
Right on the top of the.
The color, you can color also. But the pleasure which Dr. Singhvi and me are getting with that broad nib pens we are missing. I think there would not be any.
There is a broad nib pen even in the preview options.
Your Lordship are right. Well, that I know. Lord. There are several options. We have only one nib. Lord, here there are several. Your Lordship are right. I stand corrected. Then, can you see appointing authority? In relation to any grade means the authority empowered under the central services, classification, control and appeal rules to make appointment to that grade. Then, my lord, cadre, services, then composition of services. Then kindly come to Rule 12. Lord, at the foot. The same rule, Denic Rules 2003. Every members of the service allocated to an administration. Administration means NCT Delhi. Your Lordships have read the definition. Unless he is appointed to an ex-cadre post or is otherwise not available for holding a duty post owing to exigencies of the public service, be posted against a duty post under the administration by the administrator concerned. The administrator is NCT. By definition, Article 239 defines, and this rules also define. Then allocation of members of the service. The government shall, from time to time, allocate a members of the service to any administration for posting in terms of Rule 12. The government obviously means central government, because it's a joint cadre of several UTs will post officers of DANIC for being posted by the NCT. These rules are also not under challenge. It is submitted that DENIP rules further state that vacancies in DENIP shall be filled on the basis of civil service examination conducted by the UPS. Your Lordships can skip and come to DAS. So DAS is the third tier and not the last tier. Lord, may I take 15 minutes after lunch? Only 15 by the clock.
You can continue.
I have to.
Only 3 paragraphs are there.
Now, 3 paras you want to complete right now?
Please, Manas,
I
will barely finish at 4 o'clock. Your Lordship has got mentioning. I will barely finish at 4 o'clock.
May I have your Lordship's leave to mention, my Lord? Would your Lordship be allowing us oral submission?
Your Lordship
Right, I see.
Your Lordships had rejected this prayer on Thursday. If your
I
Lordship
don't
has
think it
Balas,
behoves Dr.
applications on
Singhvi's
either
trying
side,
to say
we
things
can have
like
so many
this.
applications, Balas.
Where assistance is to be given to the
We've
Constitution
got
Bench.
mentioning at 2 o'clock, so we'll take up mentioning. Do you want to take mentioning at the end? So, mentioning end mein
My
rakhiye.
Lord, I just want to know, would your Lordship be hearing me, my Lord, orally, or would you want?
We'll circulate a notice
Yes.
that we'll commence at 2 o'clock and we'll take up mentioning after CB is over.
kindly.
So we'll take.
My Lord, would your Lordship be hearing me, my Lord? I just want to know,
Lord, I'll just make a request. I'll tell you, Lordship, why.
I will also have associations then. Manas. What's the point of it? Manas? This is really a
There is no association, there is no other association.
association.
Mr. Sarve, now everything has been covered by.
The constitution
On
is
Prem
ending.
Kumar Jain, that Mr. Salve, he said, I will deal with, he said, all right, I will not.
Manas, that's not fair. With great respect, Manas. This
This is a matter where, life coming from anywhere.
I've never heard of Manas.
All right, we'll
Interveners
see.
I mean,
We'll see that.
interveners coming with this kind of time constraint, Manas.
you